Hi, I'm Lise Wheel with Law and Crime. Okay, you saw it there. We are in the jury instruction portion of the Tex McIver case. Our preeminent, well, used to be preeminent, lawyer there in Atlanta. We are in the scintillating trial part of the jury instructions. I say that, my eyes are not rolling, really, they're not. But for both sides of the trial, the jury instruction portion is not the most exciting portion, and probably not for the jurors who are actually hearing this, the instructions read. In fact, the jurors are probably going, just let us get back to the jury room and start deliberating on this thing. We've heard the evidence. We've heard these closings. Did you hear the closings? Did you hear the prosecution's closings? Were they a little bit over the top? Usually I say that about the defense closings, but here, I mean, the prosecution's closings were, well, we'll talk about that in a few minutes. We've got a lot of time here to talk about this. Anyway, so if you want to go straight to the live stream on the jury instruction closings, not sure why you would, but anyway, if you want to, you could be doing that on the live stream. But meanwhile, you can be talking to us because we have so many things to talk about. With me here in studio, I've got Dan Schorr. He is with Kroll Investigative Company. Now, it's just such a short name. It used to be a longer name, but it's now just Kroll, an investigative company, and used to be a former New York City prosecutor. And I knew you from many days ago at Fox. You and I had many days there. I think you're terrific, and I'm glad you're going to be spending time here in the studio with me. Prosecution went maybe a little bit overboard in the closing, which we're going to go back to in a little bit. So in the last 30 minutes or so, maybe 20 minutes or so, we put up on Twitter a poll with our viewers, our listeners, and there it is right up there. Okay, let me see. Let's see here. We have a poll, murder, involuntary manslaughter, or not guilty. And guilty, 31%, guilty involuntary manslaughter, 37%, and 32% not guilty. Okay, so you know what? This does not surprise me. What do you think, Dan? It doesn't surprise me in the sense of involuntary manslaughter is ahead. That's the lesser included. That's the non-premeditated guilty verdict. And the reason it doesn't surprise me is sort of because it's guilty, it's a crime, it's not an accident, but there's no premeditation involved. And it's sort of an easier way to get at murder, obviously, because it's not premeditated. What do you think?
Well, Lisa, it's great to be on with you. And
it's great to have you.
You know, it's interesting. This charge, the involuntary manslaughter, is about disregarding a substantial risk. So you're being irresponsible in a gross way.
Reckless.
They say a gross deviation of the normal care.
You're gross.
And it really, it does not fit the facts of the case, either the prosecution's theory or the defense's theory. The defense wants a complete acquittal.
Right.
And the prosecution in the closing specifically said, this does not fit the facts of this case.
Don't check this off.
Don't check this off. The prosecutor compared involuntary manslaughter to someone texting and not paying attention and killing someone. So really, there is no factual basis for this charge, but we see all the time that juries compromise.
That's right.
That they think he's responsible, they don't like the way he acted, they feel he's not an innocent person here, but he might not have intended to kill his wife. And we've seen juries in the room get together and come out with a compromised verdict, and that might be this verdict, this involuntary manslaughter. But if you look at it element by element, it really doesn't fit the facts here at all. And
it was not. I'm fumbling here to get the original charges, but it was not in the original charges. It was not in the original indictment that was handed down. In the original, it had just the felony murder, or the murder, and then a felony murder and the assault. So this is something that was then added on, if you will, into the trial. And very well may have been because the prosecution saw, you know, hey, it's not really going all that well for us. We better add in this lesser included because we don't want to walk away with a total loss.
Right, I agree with that. I think if there's an involuntary manslaughter conviction here, the prosecution is going to consider that to be a win at this point.
Of course, right.
I don't think we're looking at an intentional murder verdict. Surprises happen. I think the defense wants an acquittal here at this point, and the prosecution's trying. But it's interesting. That being said, the prosecutor did go through lengths to say, don't convict on involuntary manslaughter. This is an intentional case. So they still believe in the theory of their case that this was an intentional murder, and they're still pushing the jury for that.
They are, to the point where they said, just don't even check off the box. I mean, I've rarely seen a prosecutor say in her own closing, don't check off this box, don't do that. What did you think of how it was laid up, the prosecution and the defense, as far as the prosecution being the ones that really went overboard with the theatrics this afternoon?
And you noted that before. Usually the defense is the one that
Right.
has more leeway, they're more emotional,
Right,
they're playing
of
to the
course.
jury's passions.
They're playing for their person's, usually their man's life.
And the prosecutor's usually more
Stick by the evidence, here
logical,
it is, boom,
here
boom,
it is,
boom.
element
Right.
by element. Right. And in this case, it's a little different. Maybe the prosecution feels that they need to get more emotionally involved with the jury, because that's the big hook of this case for them, is that the defendant didn't act in a responsible way and he was callous after his wife had just died. So there's a lot of bad behavior, there's a lot of reasons to dislike him, and they're trying to use that as part of the reason why they should think it's intentional murder, saying, look, because of all the outrageous behavior on his part, that's only consistent with an intentional murder. But does that prove intentional murder? It seems like it comes up short, but they're using that as part of the hook to say, it can only be an intentional murder because of the way he acted, and you should be outraged about that.
Okay, and we're going to walk it through, so stick with us as Dan and I walk it through and go through all the points that you just made. Now, to do that, we have to start with the cornerstone from a prosecutor's point of view, and that is my background as a prosecutor. I will say that I think, to be fair, and we are very fair here on Law&Crime, the prosecutors have gotten kind of beat up by some of our commentary, and I'll throw myself in there, commenting about this case. So I'm going to try to pull back and say, okay, I'm going to try to take from the prosecutor's point of view here more, and say, well, look, you know, they saw this guy, he acted really funny after this happened. Why was he taking this firearm from his wife back and forth? What is this sleep thing? What do you mean he fell asleep and then he just happened to wake up? You know, they did have this expert, you know, so I'm going to try to sort of, you know, pull and try to take some themes from the prosecution. If I were to do that, and I would always come back to reasonable doubt, use your common sense. What is that? Never leave your common sense at the door. I would give examples of reasonable doubt and all of that. And when I'd met that burden in a case, and I would come back to the basics of that in my closing argument. And so now we're going to we're going to race to a clip of when the prosecutors attempted to do that in their closing argument in the Tex McIver case. So Dan, sit right here with me, do this, and let's go to that clip, and we'll come right back on the other side of it. Lisa Wheel with Law&Crime. Direct versus circumstantial evidence. Now, people like direct evidence. That's somebody actually standing over the gun and you see them standing over the gun. That's actual direct evidence. Circumstantial evidence is much more, they think it's much more vague than that, but circumstantial evidence is just as strong as direct evidence. It just has to be explained differently to the jury, and that's what the prosecution was attempting to do here. What did you think about that part of the closing argument?
That's very important for the prosecutor because this is a
Right.
circumstantial case.
It is.
Circumstantial evidence can be the most powerful
Absolutely.
evidence because sometimes there's no other conclusion. They have to prove an intent to kill. So they're saying his statements after his wife died, such
Right.
as calling his lawyer before calling the police.
Why would you do that?
Telling witnesses possibly to change their story.
Why would you do
telling
that?
Danny Joe not to be there.
Why would
the
you do
financial
that?
motive. They're saying that's all
Right.
circumstantial evidence of an intent to kill.
Exactly.
Doesn't mean that he said, I'm going to kill her or I intended to kill her, which would
Right.
be direct evidence.
That would be
of
the direct- that would
Or
be-
someone seeing him pointed at their back.
Right.
So
Right.
that's circumstantial evidence, but circumstantial evidence can be very persuasive.
Right. Circumstantial evidence from a prosecutor's standpoint is usually most of the time what a prosecutor has, and I always liken it to having to build a house, right? And you have to use brick by brick by brick, and you have to lay the mortar, and I don't know, I'm very good at building houses here, guys, but you put the cement and the mortar and all that kind of stuff, and you have to build it like this, like this, like this. It's not like you can just build it all at once. You don't have just the prefab all together, which would be the direct evidence. We've seen the guy actually, somebody seeing the gun, and it's all wrapped up together. It doesn't usually work like that. Like life doesn't work like that. Life is a bunch of indirect or circumstantial evidence. So, but explaining that to the jury is very important. And I think actually they did a decent job in their closing argument of explaining that. And if the jury is sort of following that, I think that part of it's actually fine.
Right. They did a good job of explaining that, and I'm sure the prosecutors had a lot of experience explaining that.
Right.
Because that's a standard
That's
prosecution
absolutely
101 of here's circumstantial, here's direct evidence, here's
Right.
the difference. And a good lawyer can make those connections to say, you saw this, you saw that. Together, circumstantially, it's overwhelming that you should reach this conclusion.
All right, now let's talk about the quality of that circumstantial evidence. The fact that he did act kind of funny there at the hospital. That why was he running? I mean, his wife is still hanging on, and he's running to the best friend, going, you know, don't say anything that why you were here, or maybe you weren't here, or whatever the heck that was, or calling his lawyer. I mean, really? Your wife's not even dead, and you're calling your lawyer, and you're working, and this doesn't look good? I mean, come on, man, you should be caring about your wife, right? And then shortly after the whole fact, then he calls a PR agent. I mean, really, again? Or he starts selling her clothes and her furs, and, you know, there are a lot of things that just don't look good about that from the prosecutor's standpoint. Of course, if I'm the prosecutor, I'm going, that looks like guilt to me.
Right. So the prosecutor proved beyond any doubt, beyond a reasonable doubt, that he acted strange after his wife died.
Very strange.
They proved beyond
criminally strange.
They proved beyond a reasonable doubt that he acted in a way that was seemed callous, and we might not morally approve of the way he behaved. They've proven all that, but does that mean that he then intended to kill his wife?
But these are the things. Unless, okay, to be fair again to the prosecution, guys. Unless you can get somebody to come into your office and go, yeah, let me just get out a little piece of paper here, and do I have something to sign a confession for you? I mean, unless you get that, then what else do you have? You have to get into somebody's head. How do you get into somebody's head? By all of this indirect circumstantial evidence. That's how you do it.
Right, but does the prosecutor have evidence beyond what he did afterwards? Can they show in the car that he... You know, they tried to show the trajectory of the bullet wound. That it was inconsistent with someone holding it low. Things like that might be.
And the weight of, I mean, the fact that, you know, it took a lot to actually, he says, well, I just sort of woke up and it just kind of went off, you know, it was an accident. But they had some inconsistency, I grant you, and that was not good for the prosecution there. They're their own witness where the gun went off.
Right.
That wasn't good. But they did have something they were going after, which was that, you know, it took a lot for someone to actually pull that trigger.
And the question is, do they have enough circumstantial evidence of what happened in the car to prove beyond a reasonable doubt that this was an intentional killing, other than things that he did afterwards, which seemed to show consciousness of guilt, but there may be other explanations for. One thing that the defense brought up in the defense closing was, hey, you don't have to like this guy.
Oh.
We're not saying he's a good person.
Not a good person.
And, you know, I've done that as a prosecutor. As a prosecutor, sometimes I've had victims of crimes who were not the best people, but they were attacked. And I've had to say, look, I'm not asking you to like this person. I'm asking you to follow the facts, follow the law. And here they're saying, you don't have to like him, but that doesn't mean he's guilty of intentional murder. So the prosecution certainly has proven beyond any doubt that he acted in a way that we wouldn't morally approve of, and that is strange, and seems to be inconsistent with someone who accidentally killed their wife. But then again, it doesn't seem to prove beyond a reasonable doubt that he intentionally did it. And that's why you may have that compromised verdict, but we'll see.
Okay, we are going to see, and we may see, who knows when, but the jury instructions are over. In the time that we've been talking about this, the jury is now deliberating about it. So whether they're going, wherever they're going, whether they're going for that split the baby verdict of, you know, involuntary manslaughter or not, whether it's just going to be a complete all acquittal or a murder conviction, felony murder conviction, or a hung jury, we don't know. But they are now out. I clocked it as of about 3:27 our local time. So they're out now, and they're deliberating. So Dan, you mentioned credibility of the witnesses as key, especially in a circumstantial evidence case like this, which is mostly what this case is based on. So let's go back to the prosecution's closing, which we'll pick up from this afternoon, in which they talk about the credibility now of the witnesses, which is paramount in a case like this for the prosecution, built on circumstantial evidence where key witnesses and their credibility is so important. Let's go back. We've been watching the prosecution in the Tex McIver case. Tex said, an accident on Hill Street. Well, calling it an accident rather than a shooting, i.e. when he shot his wife, Diane, and she later died. This is what he's saying the next day. Come on, Dan. I mean, doesn't that show consciousness of guilt when he's trying to mitigate his own actions, when he's already told the best friend to say that she wasn't there, when he's already, called a criminal defense lawyer? Isn't that an absolute classic standard of consciousness of guilt? And that's what prosecutors love and defense lawyers hate and try to massage and get away from?
That's certainly the strongest part of the prosecutor's case, is that he acts as you would expect someone who intentionally killed their wife to act, that he's giving inconsistent stories.
Think OJ in the car chase. Right. I mean, classic.
He's telling Danny Jo Carter to say she wasn't there. Why do you do that if you're innocent? And that's certainly a major part of the defense theory here, that, look, he's acting like a guilty man. However, that alone doesn't prove guilt beyond a reasonable doubt. It's the strongest part of their case.
But they're little pieces. As I get back to my building your house and putting brick by brick, I mean, isn't the jury right now, as they're deliberating, folks, they are deliberating right now in the Tex McIver case, right now, isn't that what they're thinking as they're going back there? Aren't they putting all these little pieces together? This is what the prosecution hopes anyway. Well, putting these pieces together and thinking about that.
And the defense did a great job of twisting this around in their closing, because the defense said, look, if he intended to kill his wife and he planned it out, wouldn't he have had a more consistent reaction after, because he would have thought it through? He would have acted more consistent with someone who had accidentally killed his wife. Now that's how the defense is trying to say, look, you may think this is a weakness of our case, but it's actually a strength, because if he planned this out smartly, he would have done a better job after he had shot her.
Okay. Now you just played right into my hands. Thank you so much for that,
You're
Dan.
welcome. Anytime.
Great segue. We are going to go to the defense and their beginning of their closing argument, but I want to just push back a little bit on that, and I promised you I would give them a little bit more, props to the prosecution here, because look, let's assume that Tex McIver has planned this out. It's premeditated murder. He planned the whole thing to shoot his wife, and he does it as planned, per plan. Everything goes according to his plan. This is the first time he's murdered somebody, and it's his wife. And he's done it, but it's the first time he's murdered somebody, and it's his wife. And he doesn't react just according to his plan. I mean, he is a human being after all, and so he does sort of panic in the moment. I can see that too.
That's a plausible theory, and a related theory idea is that when you kill someone intentionally, it doesn't have to be planned in advance. As we know, intent can be formed in a moment.
Exactly.
So let's say he had the gun and he decided, okay, I could shoot her right now and I could get away with it.
Right.
That's still intentional murder, even though it wasn't planned out. And if that's what happened, he might not have known how to react. And as you said, he just killed his wife. It's got to be upsetting.
Right.
So there are different possible explanations, and that's where the lawyering comes in to convince the jury to accept one side's version of the facts, or one side's inferences from the facts versus the other side's.
And as we know, the lawyering, as it is over, because we did have the closing arguments already, but we get a chance to look at them again, as we'll go right now to the defense closing as we wait for a jury verdict in the Tex McIver case. So obviously, if it comes in, we will break from this, but we're going to go to a clip of earlier today of the defense closing, and then we're going to come, Dan and I will be back to give you some analysis on it as we wait for the jury verdict in the Tex McIver case. Okay, now with jury questions, we have the questions. We don't have the answers yet. We'll get you the answers as soon as we have them. The questions, though, are 3 questions. One, they want copies of the jury instructions. The attorneys have answered. We have the answer to that. First answer is what? Question mark. The second question from the jury are, can we have the gun unlocked to test it? Now, that's critical. And the third question is, can we have tape, paper clips, and note cards? Dan Schorr, what do you think of the questions? Let's go through them one by one. The jury wants everyone to have a copy of the charge instructions. What do you think? Would that be allowed in New York?
In New York, it would not be allowed. The judge would read the charge again. Usually they don't want the jury to have the law with them, right? So they'll give it to them, they'll give it to them orally, let them hear it again and say, if you need to hear it again, we'll read it again. And this is always a challenge because the jury are lay people and they're trying to understand a lot of law that even lawyers sometimes don't understand the nuances of. So you're asking them to just understand it based on the judge reading it one time.
Right, and that my experience was mostly in federal court, and that would be the same in federal court as well. And I understand that the jury could be a little bit confused here, especially because, don't forget, in the prosecution, as we showed you earlier, the prosecutor actually said, don't check off the box. She said to the jury, don't check off the box of the lesser included of the involuntary manslaughter. So imagine if you're that jury or the jurors and you're sitting back there in the jury deliberation room and you're looking at it going, wait a second, didn't Madam Prosecutor tell us not to check off the involuntary manslaughter box that's in her column for a win, shall we say, for the prosecutor? That must be kind of confusing. So if you're sitting, again, if you're a juror, you're going, you know, maybe we should ask the judge for the charging instructions so that we can read those, and without Madam Prosecutor sort of in our head, we can actually read the law. I get that. I get just on that one point where that would be relatively confusing for the jury, and they would want to actually read that rather than have the prosecutor's words sort of ringing in their head. So copies of the charge instructions, that's out there. Can we have the gun unlocked to test it? I certainly know from my experience that would be a resounding no. But Dan, tell us.
I agree. You usually don't want them to play with the evidence and try to get their own theory about how the evidence works. They're supposed to rely on the experts, the witnesses, what was demonstrated in the courtroom, because if they start being able to fiddle with it, they're creating their own almost testimony about, oh, I pulled it like this and it worked like that.
Right.
So I think there's going to be a no. And just going back real quickly to the charge, I think the judge would probably ask them to narrow it down. Like, what specifically do you need in the charge? Not just, because I'm sure they don't want to hear everything all over again.
If there were pictures of it admitted as evidence, for example, blow-ups of it admitted, you know, as pictures of it, that would be potentially a different story.
Right, then they're giving the evidence.
They're giving the evidence, exactly. But jurors actually playing with the gun, that's going to be a problem. Okay, can we have the tape, paper clips, and note cards?
I don't see any harm. That's really a judge-by-judge decision on how you want your courtroom to run.
Wait a second. The judge has said yes to all three requests. So I guess we're wrong on that second one. That means a yes on jury instructions. So the jury is actually going to have all the charging instructions. When I say jury instructions, I mean the charging instructions. Same thing in the jury room. The jury is going to have the gun unlocked to test it in the deliberation room, and of course they're going to have tape, paper clips, and note cards, which neither of us thought was going to be an issue.
This is very different than my experience in the New York courts. Maybe there's a different practice here with either this judge or the courts down there, but it's interesting because the jury's now going to be able to sift through all the law, debate it, kind of create their own reenactment of a crime. It seems strange to me, but
well, and the third one, which is maybe the least important on its face, can we have tape, paper clips, and note cards, is important in the sense that they're really diving in. They're not just, I mean, they may have taken a vote and then obviously didn't come up with the verdict on the first vote, but tape, paper clips, and note cards, they're really diving into this one. They're going to be clipping things up and doing things left and right, and they're going to have things, and they're going to be cutting and pasting, and they didn't ask for scissors, but whatever. They're really going to be looking at the evidence in this one. They're going deep, and they're going to do a deep dive into it. And so will we now. We're going to go back to where we were just a few minutes ago. We'll come back, obviously, if we have more jury questions, but let's go back where we were to the defense closing. All right, back to the defense closing. Well, I'm Lisa Wheel. I'm back with Law&Crime, and we've just been listening to more of the defense closing. It's really pretty good, Dan Schorr, don't you think? I mean, he's really going into, he starts really strong, I thought, he says, I don't need to just give you one reason to believe me. I can give you 16 reasons to believe me. And starts going through that. And then he really kind of goes straight into motive here, which, as you know, a prosecutor doesn't have to show motive, doesn't have to show the reason that Tex McIver would have done this. But come on, everybody, every jury, every person wants to know, why would a guy just up and murder his wife, right? So
Right.
did the prosecution make a mistake in bringing motive into this, and now the defense gets to play on that in their closing argument?
Well, I don't think the prosecution had a choice here because, right, motive isn't an element of the crime.
No.
But in order to believe beyond a reasonable doubt that there was an intent to kill, a jury is going to want to understand motive. So the prosecution
Why?
has
The
to
why.
try
Right.
to supply motive. And in this case, it seems like that is the weakest part of the case. They tried to make this financial motive that his wife was going to call on a loan, that she may have been changing the will, that he was going to gain financially, that he was able to sell all her property afterwards. But
Some
that's
furs, and I mean,
right,
there
and
was
some of that
more
went
than
to
that.
pay
I'm
off
making
beneficiaries
fun,
of
but-
her will.
Right.
So that really didn't end up being that strong. And motive is certainly the weakest part of this case. And the defense is really trying to push that. Why
Right.
would he kill his wife? Did he plan this out? Did he have this supposedly nice evening with her and then just decide while they're in the car, I'm going to kill her? What is the motive for him killing her? And if it's not financial, what else was there?
Well, there was this little masseuse on the side. They sort of intimated at. I mean,
And
that was kind of weird.
The
that the
defense
masseuse
certainly
was
played the
there.
outrage card on that because they talked about how the masseuse, who the prosecution had strongly implied might have been having an affair with Tex McIver,
Absolutely.
and she got on the stand and the defense elicited from her how that was so mortifying to her that there was this untrue accusation that she was having an affair and it's been in the media and it's hurt her. And so the defense really pushed back hard against that
Yeah.
accusation.
Yeah.
So it's hard to see what the prosecution really convincingly showed motive here to be.
Okay, and right, and in and even in the financial, which wasn't as sort of outrageous, if you want, for the defense. Even on the financial, they had an expert come on the stand and say, look, I mean, shortly after the accident, murder, whatever, the death of Diane, Tex McIver sold off some shares in a company that were worth something like $740,000. I mean, this guy was not hurting by anybody's standards, even a wealthy person's standards. So, that kind of, to me, that really hurt the prosecution's case right there.
And she was earning a good living, which she's no
Right.
longer earning, that he was,
Why would he
was
do
gaining
that?
from
Right.
that. Right. So what is the motive here? Is it financial? Is
Right.
it the affair? That hasn't been shown conclusively.
Okay, then from that, then he went on to that night, the dinner that they'd had, and the golfing, the dinner, and all of that. And he says, and he kept repeating the word "nothing unusual." He said it. I didn't count the number of times, but it was over and over and over. That was kind of his mantra: "Nothing unusual, nothing unusual." To play the prosecutor here for a second, I'm thinking, well, if you plan a perfect murder, you make it look like it was nothing unusual. Do you think a murderer is sitting there sweating and like, oh, that's not a very good murderer? The good murderers make it look like it was nothing unusual. Come on, Dan, that's like a point for the prosecution that it made it look like it was nothing unusual. Just a regular old night out. Just going out for dinner, that's nothing unusual.
And that could have been part of his plan. The defense here is saying along those lines, look, if he did it intentionally, he either planned it in advance.
Excellent murderer here.
Right, he either planned it in advance or at the time he shot her, he had the intent then. And if you look at what the defense is saying, if he planned it in advance, wouldn't he have picked a better spot when they were hunting, when they were alone? Why would he do it next to
get a
her
witness.
friend?
Best witness.
And that's the prosecution theory. He's saying, but look, he could always have said it was an accident, and there would be no one around at all to even know how he got the gun. Here, he asked.
But you always know it's the husband that they look at, especially if the husband has taken a loan out from the wife, which is what had happened here. Of course, they'd be looking at him. Here, he has the perfect witness, which is her best friend.
But it does seem like a strange opportunity to kill his wife. He's driving in the car with her. He doesn't
Even
know
better.
He doesn't know they're going to be going into this detour. He didn't
Doesn't
decide where to
he?
drive. Well, remember they were driving. Supposedly he wasn't paying attention to where they were
Supposedly.
going. According to Danny Joe.
According to Danny Joe.
Reasonable doubt. All you need is reasonable doubt. So, right, the prosecution can say, look, this was a perfect setup to kill, and the defense can say, look, this really is not a great time to intentionally kill your wife when there's another witness there, when he didn't know what road they were going to be going on. He didn't know he'd have an opportunity to ask for the gun because there were what he thought were dangerous people around. He didn't know that was going to happen.
What he thought were dangerous
Right.
people around.
When he said, look, I need my gun, but how did he know in advance that they were going to go through a neighborhood that he could arguably say he needed the gun for?
Okay, then we get back into that. That intent could be formed instantly, or
Right.
just in that, I've had in the back of my head for a long time, I needed to kill my wife, or I wanted to kill my wife. I didn't know when to do it. But this is now the perfect opportunity, and I got the perfect witness. Oh my gosh, this is it.
And that's much more believable than he planned this out in advance, in my opinion, because if you're going to plan it out in advance, as the defense said, it seems like you would have picked another spot. But if he had been thinking about killing her, and suddenly they're in this neighborhood where he could credibly ask for the gun, he's sitting there and he's thinking, oh, all I have to do is fire it, and I could say it was an accident. If it's an intentional murder, that seems to be more logical than he planned this far in advance and decided to execute it while he was driving with her and her friend.
Okay, then there's the issue about which hospital to go to. And did he go to the right hospital? Did he pick the hospital that wasn't as good as a trauma care facility? And they didn't go to the hospital that was as good as a trauma care facility. And that might have been part of his devious plan. So says the prosecution. The defense says, look, they're all jumbled up, and this is this is where they went. It had nothing. It was not a devious plan at all. Now we're going to go back to the defense, where they keep going, and they're going to talk now more about what happens to Tex McIver when he's at the hospital, the movements after he gets to the hospital, the calling of the criminal defense lawyer. Prosecution, remember, has played that up, Dan, as you remember, has played it up as consciousness of guilt, calling the criminal defense lawyer, talking to the best friend, saying all of that, saying this was part of Tex McIver's premeditated plan to play it all out, put everybody into the mode to make this the perfect murder. Defense said, hey, this is a guy who realizes his second wife is dying. He just shot her. No issue about that. It looks bad. He better protect himself from this horrible accident that just happened. Let's go back to the defense closing.
Yeah.
Whoever planned a murder saying, honey, please hand me the gun. That was a great line for the defense. I mean, Dan, it does seem a little incredible. The defense is making the argument that certainly this couldn't be premeditated murder because he wouldn't be, imagine the scene, he wouldn't be driving down this road after dinner, and the gun has to go back and forth. And he has to, as the defense points out, he has to ask the victim, it turns out to be the murder victim, to hand him the gun so that he can then shoot her with it, and she ends up dead with it. And he also points out, of course, that she says it's an accident. So what do you make of those two pieces of evidence?
It shows that his actions leading up to the shooting and right around the shooting seem to be consistent with not intentionally killing her. But then his actions after the shooting seem to be more consistent with someone who did intentionally shoot her. And that's really the difficulty in this case and why the verdict could go either way, because there isn't a consistent mode of behavior by him. If he wants to kill her, why is he asking for the gun like that? Why is he choosing that moment? But if he didn't intend to kill her, why is he asking people to change their story and not calling 911 and looking for a defense lawyer right away? So it doesn't add up. It's a very strange case. And that's why we may have this compromised verdict, even if it doesn't fit the facts perfectly. The jury's going to have a tough time wrestling with this. Are
you saying that if he didn't do anything wrong, let's just take that for a second, although, I mean, he did end up killing his wife, that if he just not called anybody, not said anything to anybody, and just left it alone, he might not have been charged for murder?
If right after the shooting he called 911, said, my wife's been accidentally shot, I need help, went to the hospital and just cooperated and didn't do anything strange, didn't try to sell her belongings, didn't tell anyone to change their story, it's hard to imagine that we would be here today, that there would be any criminal charge here.
Interesting.
Even if he intended to kill her.
Even if he did,
It doesn't seem like there would have been enough evidence to prosecute him.
Even if the will was out there and all of that kind of stuff.
Maybe
they would never
they would say, look, it's a scenario where someone usually doesn't try to kill someone, driving in a car, they didn't know where they were going, there's a friend right there, and if he acted just normal afterwards, and of course, the other side would say there's no textbook normal for how you act after your spouse is shot and killed, but then again, one would think you would try to get emergency help. You wouldn't be thinking about who's going to say what, who's going to say they're there.
You wouldn't be maneuvering that.
Trying to get a PR person, then soon after thinking of selling things, although the defense argued that that was part of trying to get money for the people who were owed money in her will. So there's different ways of looking at it, but if he acted differently after, it's hard to imagine that he would have been charged here. And that's part of the prosecution's case, that he acted with consciousness of guilt. And you act with consciousness of guilt
if you're guilty.
If you're guilty.
Yeah, that's true. Okay. We've had this Twitter poll going on with our viewers. So we have an update on the Twitter poll. So there we go. Okay, let's see. So we are split again.
It's a tight race.
Let's see, tight race. Okay, it's tightened up a little bit. 32% guilty of murder, 35% guilty involuntary manslaughter, and 33% not guilty. So it's tightened up a little bit. I believe it was 37% had been involuntary manslaughter a little bit before. So it's tightened up a little bit more. But it's exactly like you were saying just a minute ago, of sort of splitting this verdict. And now, don't forget, this poll has come in after we know what the jury has got right now, which is they've got the actual gun. They asked for that in their questions, so they're actually back there, maneuvering the gun, and they've got their stickies and their Post-it notes and all of that, and their cards, and they've got that, and they've got the jury instructions, so they can look through first-degree murder and the lesser included. They've got all of that as they go into they're going into very soon their second hour of deliberation in the Tex McIver case.
And I think one of the big questions, let's say the jury split the way the Twitter poll is, that a third of the jury thinks it's involuntary manslaughter, a third think not guilty, a third guilty. Then the question is, do the not guilty third hold out for an acquittal, and then you have a hung jury, or an acquittal, or does the third who think he's not guilty compromise with the third that think he's guilty and say, even though they're not supposed to do this, and say, let's just do involuntary manslaughter and split the baby? So how solid is that bottom third of not guilty for the defense?
That's a long way to go from not guilty to premeditated murder.
Well, I'm saying they may compromise on involuntary manslaughter. So with the people who think he's guilty, because sometimes they'll reach a compromise verdict like that. Or do the not guilty people hold hard to not guilty? Now that compromise wouldn't happen quickly, but
I'm going to say that, yeah, that's still, because if you really think as premeditated murder, that's intent. Again, it doesn't have to be thought out for weeks or months or anything like that, but that is an intentional act. That's not reckless conduct or reckless disregard or anything like that. That's intent.
Right, and a third of the poll, let's say it's a third of the jury instead, think he's not
guilty
of
at all.
anything.
Right.
Are they ever going to move with the people who think it's intent to compromise? Those compromises don't happen quickly. That happens when people are locked in for days, and we're a long way from that.
And that's maybe the sticky notes and the Post-its and all of that, and the cards, and who knows what they're doing right now. And the jury instructions. Don't forget, they have the actual law now. They can be parsing the law.
Right, and one thing you never know about those jury questions is one juror asking that, or are they all asking for that? So is one saying, hey, I want to see the gun, so they ask for it so that one person can do something with the gun, or are they all saying collectively, let's all reenact this with the gun. Maybe you could sit in that chair, I'll sit in this chair, we'll play with the gun, and we'll look at the trajectory. We don't know how far. And this is one of the stressful things of being one of the lawyers in the courtroom. You're trying to read the tea leaves. And thinking, well, they asked for this. What does that mean? Does that mean I'm winning? Does that mean I'm losing? And you really don't know.
Well, I will tell you from a prosecutor standpoint, and you know this too, the more time that goes by, you don't like it.
As a prosecutor?
Yeah.
But on the other side, the quick verdicts usually are not good for the prosecution, because usually you're not going to convict someone of a serious crime within an hour.
That's true.
You want that middle ground.
Yeah,
they've thought about it.
They've thought about it. They've gone through the law. But this isn't that hard of a case, though, on the law. If you don't go, the prosecution said don't check that involuntary manslaughter. So you go back and you say, I think he did it, and I think he planned to do it. Boom. That's a pretty easy verdict.
That's exactly right. There's no legal issue about, does this count as intent? Does that count as intent? It's either he wanted to kill her,
and he
or
thought
he
about
didn't,
it.
And maybe there's this recklessness based on deviating from the standard of care.
It's not that hard a legal case.
Right.
Oh boy. Ugh. Okay, but I will tell you, both sides, whether you're prosecution or defense, are very nervous now. I mean, it's just, I'm sorry, it's the worst part, waiting for a verdict. Wouldn't you agree?
Absolutely. There's nothing like it. And when the jury comes out to read their verdict, there's no moment that I've experienced like that, where you have someone accused of a major crime, you have a victim who's either deceased or in other cases alive and waiting to see if they'll get justice. And people's lives will be changed on the next couple of moments.
As you wait.
There's no drama like that.
And this is real drama. This is as one side or the other said. I think it was the defense said. This is not made up. Courtroom.
Right.
This is real.
Yeah, this defendant's looking at spending the rest of his life in prison versus going home free today.
Yeah.
So that's a major difference in the course of his life, his family's lives.
Yeah.
So the lawyers are stressed because they care about this case. The defense is invested, the prosecution's invested. Right? Absolutely. But the defendant, he's the only one who actually will be in prison for the rest of his life or a free person after this.
Yeah. On that note, let's go back to the defense, which is trying to make sure that he is going to be a free person at the end of this, as Dan just said. Go pick up on the closing argument for the defense. All right, back in the actual courtroom with the Tex McIver case, we have heard that the judge has heard from the jury who has said, look, we want to stop our deliberations today at 5 o'clock, 5 p.m. sharp, but we are willing to come back tomorrow and do and have our deliberations go beyond 5 p.m. tomorrow. So we've heard from the judge to the lawyers explaining that the jury is willing to go beyond 5 p.m. tomorrow. Dan, what that tells me, obviously, is they're not going to finish up today with their deliberations, and that they're willing to come back and be fresh tomorrow. After all, they've heard, 4 or 5 hours almost of courtroom closings today. Then they had to wade through the jury instructions. Then they've been through now. It'll be an hour and a half when they stop for deliberations today. That's a lot that they've gone through, and they want to be fresh tomorrow. But they're saying they're willing to stay beyond 5 o'clock tomorrow. What do you make of that?
Well, clearly they're not close to a verdict, because if they were close to a verdict, they would just stay late and get to the verdict.
Through it, right.
The fact that they're already anticipating that they might stay late tomorrow shows that this may go on for a while.
Right.
This jury seems like a very serious jury,
yes.
and I say that in part because of the questions that they asked. In here, you can ask questions from the jury. You can't do that in New York. You can't do that in federal court.
Right.
But here they can, and they asked a lot of questions. So that shows that they're thinking about the evidence. There's a lot to sift through.
Right.
This was going on for weeks, so I guess they're hunkering down and saying, we're going to be doing this for a while. We don't want to go past 5 today. We've had a long day.
Right.
Start fresh tomorrow, and we're willing to work late tomorrow. And that seems like a responsible position to have.
Right, and no one will be bothering them. No pesky lawyers bothering them or anything like that.
Right.
If they have questions, they'll obviously be answered. So we were just hearing the defense closing. The defense was just talking about it's no crime to have a gun in the car with you, which in Georgia it is not. So there's no crime in having that. And the defense was going through very methodically saying it's no crime in doing this. It's no crime in the way Tex McIver acted. This was not pre-planned. This was not planned at all. The things that he did show, just absolutely not the intent, absolutely not an intent of anybody who would have planned a murder, right?
Right. He said, what kind of murderer starts by saying to his wife, honey, please hand me a gun?
Right.
Now, the prosecution side will say that was what was so clever about it. He did it at a time where she was vulnerable, had no way to suspect him, that no one would think he was doing it intentionally. And the defense is saying, no one would do it like this, and therefore he didn't do it like this, and he didn't intend to kill her. Right,
and he said that the prosecution threw out a bunch of red herrings. He made a slip at one point, and he said, I'll show you that, you can have zero doubt. Well, of course, reasonable doubt is not, nobody in a prosecution, the best prosecutor in the world, cannot leave you with zero doubt. That's not beyond a reasonable doubt.
Right. He said there's reasonable doubt here, reasonable doubt here. There's no way you can have zero doubt. And then
that's not the standard.
Right. Then he shifted back after that to the reasonable doubt standard before the prosecution can object. I know as a prosecutor, it's bad form to object during your closing argument.
I would have stood up on that one.
Yeah, at that one you have to.
Very gently,
he corrected
but I would have
himself.
stood up.
But then there's always the times where the person's going too far, and should I object, should I not object? I don't want to look obstructionist, I don't want to look like I'm interfering with their closing, but then again, standard of proof, burden of proof, reasonable doubt.
You can't have that shift.
Right.
I mean, that is so critical, because if the prosecution or the defense for a minute shifts that burden of proof to the jury so that one juror thinks that the burden of proof is now zero doubt, that they have to have zero doubt in coming to a guilty verdict on Tex McIver, well, they'll never get a guilty verdict. I mean, that'll just never happen.
This was very well argued by the defense. One line he used that I liked was, this is one of the most important decisions you will make in your lives. And I
Right.
think that weighs heavily on
course.
them. And I think if people are nervous about making a decision, they're going to err towards the not guilty verdicts, because otherwise they're putting someone who might be innocent in jail.
Right.
Certainly that's what the defense is thinking when they
Of
say that to them.
course.
This is one of the most important decisions in your life. So don't convict him lightly.
Right.
And here's all the reasonable doubt.
Kind of running very close to an ethics rule, which of course I know that you know, which is that you can't put the jury in the shoes of the defendant, or you can't put them in the shoes of anybody in your family or anything like that, because you can't put the juror quite that close. You can't do that. That's unethical for a defense lawyer, certainly for a prosecutor, but also for a defense lawyer to do that. So it's kind of getting close to that. Another rule that's sort of akin to that is that you can't let the jury know in any way, shape, or form what the punishment might be. You know, that if they say they come up with a premeditated murder as opposed to involuntary manslaughter, that of course the punishment is going to be different. Now, of course they know that the punishment will be different, but you can't talk about punishment. So you can't say, hey juror, you know, if you convict them of this, they're going to get a lot more time than you can convict them of this. You really better think about that a lot more. You know, be very careful about that, because the punishment's going to be a lot greater. You can't talk about punishment in this phase of a trial.
Right. Now, they're going to know that an intentional murder conviction will send them away for life, but for the involuntary manslaughter, they're not going to know what the sentencing possibilities are.
They can't go home and look it up. They can't do any of that.
But certainly sometimes lawyers want to suggest that to, you know, hey, if you convict him of this crime, he's going to be punished so much, you don't want that to happen, or the prosecution, if they're trying to get some conviction.
Really close to ethical rules there.
Absolutely.
I mean,
absolutely.
I'm sorry, I'm an old ethics professor.
Absolutely.
So.
And you see the smart lawyers use language such as, this is one of the most important decisions in your life, not saying think about the defendant, but I think the implication there is pretty clear.
The implication is there. Be careful with that, though. Don't run afoul of those rules. Anyway, so let's go back to more of the defense in their closing argument in the Tex McIver case. They're doing a really interesting and very good job. Let's hear more of the closing arguments. Hi, I'm Lise Wheel, back here with Law&Crime. We're going through the closing argument here in Tex McIver case before the jury signs off for the day in their deliberations. They will have gone through about a little over an hour and a half before they sign off. So Dan Schorr, the defense is going through the count by count and just sort of trying to go through how the prosecution's case doesn't meet its match. And in talking about the counts involving the witnesses, Danny Joe Carter, he's saying it's not a crime to lie in this context. And in fact, that's really not what the state has charged Tex with. It's misleading the witness who will then lie to the cops about what happened. So misleading her, and that is, and when you look at the charge here, that is the charge, the law in the charge, misleading her. So he's going through that and saying, and that's not what happened here. So could it be, getting back to the jury question that they had for the judge just about a half an hour, 45 minutes ago, could it be that the reason that the jury wants the jury instructions is really to parse through the language here in this complex, or can I use the defense language? He called it this is not my language, this is the defense language, a weird indictment.
It's possible, but I think it's too early for the jury to be asking questions about the law around the influencing a witness charge, because they still have to resolve the murder charge, maybe the lesser charge.
Well, so see, I'm pushing back on you a little bit. I'm saying, what if they've already decided that?
It's possible,
and they're now going through this.
Especially when they're already talking about, then they're already staying late tomorrow night. They're already saying, "Hey, we're going to stay late tomorrow night." I can't imagine they're down to the last charge.
That would have mean they've already found him guilty. You realize that,
right? Or they could have said he's not guilty of that, but he did try to influence a witness.
And we're already on the lesser charges?
But I just don't see that playing out like that.
Okay.
And then and why would they want the gun then? They want to look at the gun and analyze it. They want all their tape and their cards.
Okay, okay,
Seems like there's a lot going on here.
Okay, hey, all right, Dan Schorr. Okay, all right. Woo, interesting stuff. All right, so we are finishing up the first day of deliberations in the Tex McIver case. It's been great to have you, Dan Schorr, with me with Kroll Investigations.
It's great talking to you.
Thank you so much. And we'll be back tomorrow as we continue in the second day of deliberations in the Tex McIver case out of Atlanta, Georgia. Boy, this is an interesting case. Join us tomorrow as we pick up where we left off today.